Thanks, Morel. It's just for everyone's benefit. My name's Mark Burdon, and it's 8:33 in a Friday evening here in Brisbane, Australia. Thanks for allowing Nick and I to present virtually. It's sorry we couldn't be there in person. It's been a fantastic conference. Just in terms of who the people are who've been involved in the paper, so you get a good handle of the actors before we start running through the paper. Myself and Anna are the academics from the Queensland University of Technology Law School. Nick and Ryle are PhD students, also at the QUT Law School. Josh Buckley is an undergraduate law student, and Ryle and Josh were the coders for the project. And Siobhan and Stephen from Rialto Logic were the industry partners for the project. So just so you got a better handle of who everybody is. Just before I get started, I'd just like to acknowledge the funding that we received from this commercial industry grant from Rialto, and also the fact that this is the first output of an Australian Research Council linkage grant on optimising digital compliance. That's chief investigator is myself and Anna Huggins. Partner investigator is Lizzie Coles-Kemp from the UK, and the industry partner again is Siobhan and Stephen from Rialto. And I came into the conversation just at the end where it was where Morel was talking about a shared language. I have to say we thought critically and seriously about undertaking commercially related research into legal coding. And we're very grateful to be doing the research with Rialto, not so much on the basis of shared language, but a shared commitment in terms of trying to install systems, digital systems that promote good forms of compliance. Also, in terms of, final thing, I just want to say acknowledgements. I'd just like to really acknowledge the time and effort that our reviewers for CRCL put into the paper. It's very much appreciated. Okay, so in terms of what we tried to get out of this paper, there was three component parts. One was to outline the coding practice, the methods that we undertook in terms of coding a specific piece of legislation, how that then translated into an ongoing discussion with our industry partner about using the legal code for business system purposes. For the most part, it was a smooth journey, but as we'll get to, there were some bumps in the road, and it was actually the bumps in the road and Rialto's willingness to examine those bumps in the road that really led to the identification of the interpretive challenges that we encountered. And those interpretive challenges arise in two parts. One is sort of the translation of different logics of the legal natural language logic into sort of the deontic logic of DDL. And also that allowed us to identify some other drafting peculiarities of the Act that we were working in. And again, we'll run briefly through some of those peculiarities. That led us to the application of trying to reconceptualize or conceptualize what it was we were doing in the context of Roger Brown's mindsets, but also that led us to the development of different types of coding strategy and how different types of coding strategy was necessary in relation to different legal and regulatory artifacts. So just to run briefly, just to run briefly the law that we encoded. It was the Treasury Laws Amendment, Design and Distribution Obligations and Product Intervention Powers Act of 2019. This is an amendment act as part of the Corporations Act, which is a behemoth piece of legislation. The legislation itself is currently under review by the Australian Law Reform Commission in terms of how it could be improved. It's so vast at this stage. It has a certain history to it. It was implemented following major law reform inquiries relating to the financial services sector, particularly involving predatory lending practices. It established a new legal framework around obligations centered around a new legal construct, and that is a target market determination. And a TMD requires issuers of financial products to provide information about who the product is targeted towards and why it is targeted towards certain groups of individual consumers. So in one sense, a TMD is sort of a broad-scale market-based information disclosure mechanism that in terms of better informing consumers what the basis of the financial product is, but also better informing the market the purpose of the identification of certain types of consumers for certain financial products. So it's meant to have a consumer-centric approach to product design that's meant to filter through in a compliance way throughout the whole of the organization. So compliance in this sense is much more of a holistic endeavor, which is why we have this mix, this complex mix in the Act itself of principles-based recommendations, principles-based regulation, constructs such as reasonableness, likely to, etc., but also more prescriptively focused legislative requirements. So it's this complex mix of prescriptive rules and discretionary clauses, which in terms of the coding exercise actually became quite difficult to code, as we'll start to outline. Excuse me. Sorry, I'll just have to bear with me a bit. My system's a bit slow at this end. The code that we used was based on defeasible deontic logic, and I acknowledge the work of Professor Guido Govnatori, is probably known by some in the room. And the notion of defeasible of DDL is to think of looking at the obligations that arise in the context of legal requirements. So it's coding legislation based on certain normative contexts of clauses, for example. In terms of the language that we used, it was produced by CSIRO, Data 61, called Turnip. And Turnip has two types of clause, two types of operators. Modalities and conditional atoms, definitional atoms. In terms of atoms, what we tend to use the atoms for, which are the basic variable in Turnip, these tended to be the conditions, the legal definitions that form the obligations, which are the modalities. And in terms of modalities in Turnip 4, obligations, prohibitions, permissions, and exemptions. And this was the basis of the language that we use in terms of the encoding. And again, its structure around these modalities of obligations, which led to a very different type of interpretive context. The methodology that we outlined in terms of the coding strategy. And again, I saw the presentation and the paper from Denis and Marie yesterday, and there was some interesting parallels between our work and the findings that Marie and Denis uncovered yesterday in their presentation, which we'll sort of run through in a bit more depth, particularly around micro choices and this idea of dudes in the room. I wouldn't quite go as far as calling us dudes in the room, but there's certainly an element of muddling through. That there wasn't any real sort of fixed firm methods in relation to the coding approach that was adopted, and we kind of had to use an iterative process that was developing as we went through the coding research. We adopted what we've termed really a plain reading approach, and that's based on our previous research as a counterpoint to our previous research with Data 61, which had mechanisms of statutory interpretation built into the coding process to resolve interpretive ambiguities amongst the coding team. We didn't do that this time. Instead, we had 3 legally trained coders led by a pair coding team of Nick and Josh, who worked together to code the clauses together. Both are legally trained, but both have computer science backgrounds. And Ryle conducted what we call regulatory obligation mapping, which was looked at the intersection of different types of legislative and regulatory requirements as part of that secondary process once we undertook the plain reading coding. The coders and the academics met on a weekly or fortnightly basis, and then we had semi-regular meetings with Rialta, and they were really based to try and work out the interpretive ambiguities that we'd encountered. So the way the coding process worked, Nick and Josh worked through starting from the legislation and just working through it, coding each clause that was deemed relevant, and any sort of ambiguous provisions that couldn't be coded within the plain reading approach was noted. We then tried to see if we could resolve it with a swift look at extrinsic materials in order to try and work out the problem, that we could categorize the ambiguity, and then that ambiguity was then taken to Rialta, who basically told us how they would like the ambiguity to be coded. So in that sense, Rialta acted as the interpretive oracle, with QE team just providing a plain reading of the text and the coding exercise, and Rialta then determined any interpretive ambiguities. And the final coding check was undertaken by Rialta, and that at that point the final code was agreed or almost agreed and then shipped. So in terms of some of the interpretive ambiguities that we identified, there was as I mentioned at the start, there was types that involved the sort of a translation disjunct between natural language and law and sort of formal logic and DDL turnip. And they manifested in a couple of ways. So for instance, in terms of the Act itself, and again, as we get to in the next slide, there's some drafting peculiarities within the Act. So there were certain clauses, particularly the definition of target market, which had this circular reference where one section just led to another section, and it wasn't possible to resolve what a target market definition would be in the context of a plain reading, because it just resolved in a certain loop. One of the other issues that we encountered, particularly in the context of DDL, was deontic assigning, the assignment of a deontic obligation. So for instance, say on the screen at one of the sections 1023N, which relates to a product intervention order. That's an order that allows the head regulator, the Australian Securities and Investments Commission, ASIC, to intervene where there's a certain financial product that could give a significant risk to consumers. One of the challenges with coding this section was that the way the section is drafted, it doesn't put an obligation on an individual or an entity. The obligation that arises is on the product intervention order itself, which in terms of trying to place an obligation onto something, left with this rather uncertain logical situation in which you would have to put the obligation onto the PIO itself, as you can see in this first attempt at coding. If you, on a slightly extended reading of the text, it's clear that in terms of reading the section in context of the whole of the Act, that it's clear that it's ASIC who is meant to have the primary ability to be able to draft and issue a prevention product intervention order. So we also coded the fact on the basis that it was ASIC who would have the obligation or the power to submit a PIO, product intervention order, even though ASIC isn't identified in the context of 1023N as being the body who would have that power. So we had to go beyond, again, that sort of plain reading approach. Similarly, in terms of the last part, in terms of the coding that you can see on the screen, the assumption that ASIC would be the drafter behind the product intervention order means that it also assumes that there's no reference
Okay, Nick, can you hear me?
in
Yes.
any other
Hello?
legislation.
Hello, can you hear me? Can you hear me? Yes, I think so. So we're running out of time.
Sorry, I'm just getting my own feedback.
Yes, okay, thank you very much.
Yeah.
Hello, the 15 minutes are over, so I'm going to give you another 3 minutes, but we are running very late, so we really need to be on time with this. So if you could fit the remainder into 3 minutes, I would be very happy. Thank you.
Yes, sorry. Well, let me wrap up in terms of what we were looking at. So the context of the coding that we did give rise to different approaches or different ways of undertaking the coding exercise, both from a legal mindset and a regulatory mindset. And we realized at this point that when we tried to resolve some of the coding of some of the discretionary terms, such as the meaning of reasonable or likely to, that they couldn't be resolved solely from a legal mindset or a plain reading approach, and that there had to be another additional mindset consideration that then allowed the legal and regulatory context to emerge through the code. And once we got to that point, we started to identify that there were different rationales behind different types of artifact. So, for example, the legal rationale, which has a focus on declaration, compared to a regulatory rationale, which has particularly in principles-based regulation, which has a focus on promoting discourse. Similarly, in terms of the difference between meeting obligations and establishing broader regulatory objectives around compliance, that leads to different focus on prescription and description and rules and norms. So in terms of wrapping up, building on Brownsword's 3 mindsets, the legal, regulatory, and computational, what we're looking for and what we're also looking to argue in the future is that there needs to be a 4th mindset, that these mindsets aren't striated or separate, that actually they overlap, and they also have to overlap and be in congruence with a compliance mindset based on the contextual understanding of the coding exercise within the organization. Thank you.
Thank you very much. Thank you very much for wrapping up. And I know you were in the midst of a very interesting explanation, also for us, for the conference, absolutely key. So we're very much looking forward to publishing your paper. We're now giving the floor to Monica Palmirani, who is going to provide the reply. Monica, welcome.
Thank you very much for inviting me. I have a lot of echo, but I manage. So thank you so much for the invitation. Thank you to the author of the paper. I think the paper is relevant for the community, and it is a very interesting analysis of a concrete case that help a lot to enter in deep of some peculiarity of a codification of a legal language. However, I have the impression that in the paper there are 2 levels. One very concrete and focused on a application, a specific application, a specific logic, the feasible logic, and turnip that is only a kind of a tool, and a general consideration concerning the feasibility of coding of the legal language in logic. So my comment and recommendation to the author is to divide clearly the empirical parts, depending to the application, depending to the incompleteness in case of the tool of turnip, to the general consideration of feasibility, because otherwise there is the impression that some topic are out to the research community. And I suggested to divide also the narrative, considering the workflow of the legislative process. So many of the problems detected in this work paper could be easily managed during the legal drafting phase. So mistakes, legal drafting errors, use of the bracket in not a correct way, something like of errors we can detect in ex ante phase of the legal drafting. So also in this case is not a limit on the theoretical point of view, is a matter of legal drafting that we can address in another phase of the workflow of the legislative process. And there is another, there is a flow of steps. First of all, we have a drafting, and during the drafting, and not after, we can detect some of those problems presented in the paper. And then there is a crucial part of modeling, where the paper focuses much the attention. And finally, there is another phase, the execution. The execution is when the serialization of the norms of the legislation is applied to the concrete case for the compliance. So not to divide the paper in these three main steps, in my opinion, is confusing for the reader, because I have the impression that all these problems are jump in the modeling part, but it's not. Some problems we can detect before, some problem we can resolve after, during the execution. I give you an example. In the execution, for instance, many of information that are misleading or ambiguous can be resolved by the legal expert, case by case. So some information that are vague, ambiguous, and not defined during the modeling of the abstract norm could be integrated in the execution phase as an input by the expert. It's not a matter of the modelization, it's a matter of integration in the tools, input from external events, like the weather or what happened in the concrete case of the fact. And it depends too much to the turnip maturity that this doesn't implement this kind of integration from the external inputs. So during the execution, we can resolve open texture definition, like reasonable, or as soon as possible, likely, or some parameters of the time that are not well defined in the norms and the legislation. So move this part in the execution phase, and many of these tasks could be resolved with a good implementation of a turnip project. Coming back to the modeling part, this is a core part that we are interested in to investigate. What is the real limitation of the modeling? So I recap, we have a drafting and some errors we can detect during the drafting. We have a modeling of the norms, of the legislation text, and we have the execution of the modeling. So I already presented the first and the third. I now focus my attention of the second step that is very well presented in the paper. So many problems detected, like the problem of the atom construction, depends very much to the type of a logic and to the type of a legal reasoning that we need to apply. So also this problem could be detected partially with additional level of techniques like semantic ontologies or other information concerning the definition of the atom. In the page 15, there is the claim that the deontic is not connected with information that the deontic operators is related to. But inside of many standards like legal rule-ML, these metadata are provided, and so in each moment I can link directly the ontology and to detect the information definitions, not limited to the ontology definition, but also the link to the fragment of official gazette in order to have more information and metadata originally disseminated through the official gazette. So I find in the paper a great analysis of the problems, but not the analysis of the techniques available in the state of the art that can mitigate these problems that exist, like legal rule ML, for instance, or metadata ontologies for the part concerning atoms. And concerning the time and the date that is mentioned as a problematic issue, we have also temporal logic. The literature, the scholar dedicated in the last decades a lot of researches concerning the temporal logic and these. So also this aspect of the time and the date is very well investigated in the literature. And also the exceptions, and finally also the possibility to adopt a mix hybrid AI that is mentioned also a little bit in the paper in order to address this mindset of coherence. So in case of ambiguities of some terminology in the language, we can integrate machine learning if it is available enough information coming the case law or parliamentary act in case it doesn't exist a case law because the law is new. We can take the parliamentary act and using the parliamentary act and the interpretation coming from the constitutional court or others in order to integrate using machine learning probabilistic approach, and so to offer to the end user at the hand the possibility to choose the best option. So my conclusion is that the paper is very relevant, but I recommend to divide the theoretical part and the applicative problems of the turnip as implementation software from the theoretical limits, and to investigate if there are and I believe in so, other techniques that can mitigate the problems investigated in the paper and not transform these limits in theoretical limits, but to have a investigation how semantic web, metadata, hybrid AI can mitigate these elements. Finally, I think that conceptually we need to have a different approach. The legislative text is an open text. Hart said so in the philosophy. And also in the codification, we need to adopt this approach. The first serialization is a prima facie serialization of coding, not fixed in the stone. And during the execution and more during other possible interpretation, we can add a different level of multiple coding, multiple interpretation, serialization of the same rule according to different scenarios and contexts. I give you an example. If I have a European legislation rule, I can have a European legislation interpretation, but also the same rule is serialized in different ways in Italy, France, and in Germany.
Monica, thank you. I need to ask you to wrap up in 1 minute. Would that be possible?
Yes, in conclusion, exactly. So the main idea, in my opinion, is to move forward to the idea that the codification is unique, is a part of the general norms are unique, but also it is possible nowadays to have a good manage of versioning of variants interpretation according to different situations, and to have an ecosystem that can take in care, not limited to the serialization, but all the workflow from the drafting to the execution, including another topic that today is not a matter of my comment, that is explicability of the result.
Thank you very much. That was a fantastically detailed and dense review of the paper. Fantastic. And of course, we're going to invite you to write this down in 1,500 words as a reply. And I think the author of the paper will be extremely happy with this detailed advice. We have until 2024 both answering questions and these questions, these comments, and taking in new questions. So I'm going to do the same as with the last paper. I'm going to give the authors the chance to respond. That means we forget about lunch because, you know, joking. Oh, they were coming after me to kill me. And after that, I will take questions. We will look into the chat and ask the authors to think about the questions and maybe answer the questions that are in the chat, if there are any. So the floor is yours. And we are now at 12:05. So if you could wrap the answer up, and since the feedback was quite detailed and quite provocative, I think, perhaps, if you could wrap up by 12:15, that would be great.
Sorry, Morel, is that in terms of our response?
Yes. So you have the floor. The floor is now to the authors to respond, and you can take 5 to 10 minutes for that, because I think it was quite detailed, right? Can you hear me?
It was, but unfortunately, it didn't come through very. I'm having the internet is being problematic, unfortunately.
Okay, in that case,
so I couldn't hear Monica. I couldn't hear all of Monica's response, alas.
Yeah, maybe then in that case, because the response was quite detailed, and I think it might need some thinking before replying. This is also quite in-depth and structural feedback. Maybe it's more interesting then to take questions and then give you a final word where you can respond to whatever you heard. So I'm going to take questions from the audience now. Please not all at the same time. Can I give turns? That's my moderator's privilege, right? Denis, I'm very curious. Do you have any comments? Oh, he thinks, yeah.
Thank you very much. Can you hear me? I assume so. I wanted to know what are the perspectives for the application of your work? Is it going to be used for modelization purposes or for production purposes? Has it been hard to establish the connection with the people in charge there? Maybe with respect to the experience that you mentioned that we did with Marie in our paper with respect to the French housing benefits. I would be curious to see what are the perspectives on that.
Okay, thank you very much. Sorry, thank you very much. Yes, please.
I think I got all of that. The use of the code is actually. Sorry, there's an awful lag, and so. Sorry, let me try again. Sorry, can you hear at your end?
Yeah. It's like as if you're in Australia or something. We do hear you, so you can speak up.
Sorry, is it coming through okay?
Yes. Yes, please.
It's lagging really awfully at this end, I'm afraid. So I'm not.
You can just speak.
So in terms of the question of purpose, the use of the code is to go into commercial business systems, as part of a digital compliance process. So its implementation is in various financial services firms within the private sector. And in terms of some of the challenges or some of the comparisons that I identified in relation to the talk yesterday, certainly that notion of micro choices at every sort of level in the coding process was really apparent in terms of the identification of not just the interpretive ambiguities at a sort of the more structural level that Monica was talking about, the actual more granular level of atom construction, etc. So the other thing that I sort of, which I thought was relevant, was the idea of when you use the phrase "two dudes in the room." And as I mentioned in terms of the presentation, the lack of strict methods around the coding approach was something that we had to develop on an ongoing basis. So we're working on sort of a constantly iterative basis of looking at how we could improve the coding process.
Okay, so I'm just going to read two questions from the chat. You could still respond to them if you're hearing me, and otherwise you can of course read the chat. But if you don't hear me, you don't know that I'm asking you to do that. So you know all these layers of interfaces. So the first is a question from Pauline McBride. To the extent that you are committed to a plain language interpretation, of course, courts, and not only courts, adopt other approaches to interpretation, notably contextual and teleological. Is commitment to one form of interpretation problematic? And the second question is follow-up to one of Monica's points. The problem you are having in defining atoms arises because an atom is the name of a proposition and your formal language is only a propositional logic with deontic operators. And this is a question by, or actually it's an instruction by Thorne McCarthy saying that you need a richer and more expressive language to start with. So these are quite foundational remarks, both on the side of law and on the side of computer science. We're very curious to your response.
Nick, do you want to take the one on the atoms, and I'll do the one on the interpretation?
Yeah, sounds good. Sorry, I don't know if you could hear me, but yeah. So in terms of the comment about atoms, that's something that we've talked about a bit. Actually, is what are the limitations of using the turnip language, and how does the choice of programming language actually affect the way that we can convert that natural legal language into computer logic? So it's a great point, and it's something that we have talked about a bit. In terms of future research, looking at, for example, potentially object-oriented programming, where we could then address granularity issues in atom defining, for example, because we could then actually have classes of different objects and sort of treat them the way that we, as lawyers, we tend to sort of inherently treat the law without necessarily being aware of that all the time. So yeah, it's a great point. We definitely do want to look in the future at how do different programming languages actually affect the legal coding process itself and the outputs.
And in that point, Pauline's question about interpretation, the two projects that we've run in this space, as I mentioned in the presentation, covered very different interpretive strategies. Where we looked at, the first project was solely based around interpretation in context, statutory interpretation in context, based on the statutory interpretation processes flowing from Australian case law. And the counterpoint to that, as I said, and again, the presentation was this sole focus on the plain reading approach. In terms of the resolution of ambiguities, both were able to resolve ambiguities, but in quite different ways. So I don't know if it's the context that one is more, well, certainly in terms of our research, there were definite limits in the context of a plain reading approach, but whether there is a process where you would adopt solely one approach, I think that becomes challenging in the context of its use in business systems. One of the realizations for us was the different starting points that we had in our research with Rialta in terms of what should be the interpretive locus, where we naturally gravitated towards the legislative framework, whereas Rialta's starting point was actually the regulatory guidance, which required a slightly different type of interpretation, but also a melding of both the legislative and regulatory forms of interpretation that produced that led to the production of the final code.
Thank you very much. Any more pressing questions at this moment? Okay, then I think this is it for before the lunch part of this day.